Good afternoon all, my name's Anne Kingsley. I'm the PSL for Local Government at LexisNexis. I'm delighted to welcome you to the fourth of our Local Authority Insights series in association with local government lawyers. I'm delighted to introduce to you our panellists today. So we have Kuljit Bhogal of Cornerstone Barristers. She is the joint head of the housing team at Cornerstone, specialising in housing law, and has particular expertise in cases involving antisocial behaviour. She's listed as a leading junior in social housing in the current editions of Legal 500 and Chambers and Partners. Susan Taylor is a seasoned senior solicitor at Capsticks, best known for her extensive experience in housing management law in High Court decisions and Court of Appeal cases. As well as being a senior solicitor, she has many years of experience of lecturing for IELTS students, and has experience as a non-executive director of one of the largest federated social housing groups in the Northwest. She has worked both in-house and in private practice and for a housing association. So she has a lot of experience in the field. Unfortunately, she is having some technical difficulties in joining, and you've been able to hear her. So we hope that she'll be able to join us. But for the meantime, Kuljit and I will have a conversation and hope that Susan will be able to join us very shortly. Over to you, Kuljit, to start. Just to start with the questions, can you give us, sort of, in your practical experience, the most difficult issues in presenting a case for court on antisocial behaviour?
Hi, Anne. Welcome, everybody. I think there are some issues which are going to be familiar to those of you that work in this field, which continue to be a problem. And for my own experience, one of the issues relates to mental health and how one deals with tenants and perpetrators who have mental health problems or other vulnerabilities. So that's one area where I think there are still difficulties being presented once we get to court. The other area where there are difficulties relates to training and some of the policies that sit behind action being taken. And it seems to be an area where defendants' lawyers want to ask questions about the extent to which an officer has been trained in antisocial behaviour and sometimes human rights, because that comes up in some of the cases, and then also the extent to which policies been applied. So looking at mental health, first of all, some of the problems that still occur when we have cases reach court stage is that the bottom line is that judges are very reluctant to make people homeless. They're very reluctant to make possession orders. And so when they are presented with a perpetrator that has a medical need, whether it's mental health or a physical medical need, they want to know that everything that can be done to help them has been done. And that means that as housing officers and as enforcement officers, very often you're doing much more than your day job, as it were, because you're having to almost be a support officer as well in terms of supporting the perpetrator and the victim. You will need to have made inquiries of the relevant authorities. So if you think that this is a person that might be known to social services, it's really important that you make those inquiries of social services, of the community mental health team. If they've got a key worker, speak to their key worker. Whatever support's in place for that person, you ought to have, by the time you've reached court, made inquiries of that support mechanism, and either tried to put additional support in place if that's what's needed, or be able to say to the judge, Judge, this person was known to CMHT, but the file was closed a while ago. Or they might say this person was known, but they're not engaging anymore, and that's why their file was closed. Or this is the support that's in place. And judges are much more willing to make a possession order if they get the answer from the officer. Not that we haven't asked social services or we haven't made those inquiries, but these are the inquiries and efforts we've made, and this is the response we've had. So rather than it being a case of not knowing what social services might have said, you've actually got the answer, and you're equipped to answer the judge's concerns about making somebody homeless. And that's not just with outright orders, it's with suspended orders as well, because suspended orders are just one step away from somebody being evicted. So that continues to be an area which causes concern and can sometimes create difficulties when we're seeking our possession orders or our injunction orders, because there are still sometimes unknown issues that could have been sorted out and inquiries could have been made at an earlier stage. So mental health continues to be a problem. And the other area that I mentioned was in relation to training and policy, because and I've had this come up recently where an officer's been cross-examined on whether they've had any training on how to use community protection notices. And that's one of the tools we know we can use when dealing with antisocial behaviour, alongside injunctions or possession action and some of the others. Because let's face it, the underlying problem, in terms of the behaviour, is usually pretty bad if you've got to the stage of court and trial. So no one's really going to be saying, well, you got that wrong. What they're going to be picking on is your procedure and whether you followed your procedure. And some of those points, as opposed to the actual behaviour itself, because that happened or it didn't. And it's really important that officers not only are trained in what suite of powers are, but that there's regular refresher training in terms of how those powers can be used, so that if they do face having to go to court and justify what they've done, they can do it. But also it allows them to consider whether this is a case that warrants a warning type intervention, or a community protection notice, which I would class as one of the lower level types of intervention, or whether you need to go for something more stringent, such as a possession order. You can't do that unless you know what the powers are that are available to you.
That brings me on to another point about policies and procedures, is that if you look at your procedure and your policy, often there's a list of actions to be taken prior to possession procedures, and acts as a memoir, an aid memoir, and a going forward plan, which also includes with a lot of possession proceedings and injunctions, and criticisms that are raised in defence are that the perpetrators' counter allegations aren't investigated properly. And those steps are all in the policies and procedures usually, and it's important also to do that. Absent it being a very serious case, the perpetrator should always be contacted to get their version of events. That also acts as admissions that might be made later, which strengthens your evidence if you are going to take enforcement action. But also it's fair and it's just, and it's a matter of might change your opinion as an officer when you hear the other side counter allegations, because often it is tit for tat going on and you take one-sided view. It's very important that that is investigated, and sometimes if there's counter allegations against other neighbours, that a different officer investigates that and the findings be considered and explored before the enforcement action against one party is taken. It might be that you take action against two parties in some events, which I've been involved in as well. So those policies and procedures, what I'm saying, are absolutely key, and it's not just a tick box exercise to comply with some legislation. It's very useful, and if they are very powerful, and they give you the direction you need prior to taking enforcement action if necessary as well.
I think you have to be careful with policies and procedures, because I think there's a real danger that and I found this a bit when I wrote my book, you kind of want to write down everything you know about antisocial behaviour. You sort of want to write down everything you might do if presented with a particular problem. And I actually think that the better policies are the shorter policies, because you've got less scope for people to pick holes in the fact that you didn't write that letter 5 days after this action, you didn't do this thing 10 days after, all these various that you might make in your policy document that you then can't actually follow through on, because let's face it, every ASB case is different, and you've got to decide, is this one that warrants a warning, or is this one that warrants something more than that, and go through the stages of the various options you've got and decide where this sits and where you start in terms of enforcement. If in your policy you've said, you know, we would always issue a warning letter, then that ties your hands to writing a warning letter, and then in cross-examination your officer's going to get asked, well, you didn't write that warning letter, and you'll be saying, well, because someone was stabbed and we had to do something much more serious. And of course, your policy hinders you rather than helps you in that situation.
It has to be very careful in its wording, and it's not we will, or it's we aim, we endeavour to, but there's always exceptions. And it's key, the wording in policies and procedures, that you can't get battered by your own policy and attacked for not complying with it. And that is something that has to be drafted very carefully if it's something that ends up in the court situation as well. Yeah, no, definitely.
Yeah, and I actually think, you know, I look at it from a court perspective, because that tends to be where I get involved, unless it's something high profile where I might be brought in early on to guide on the various options. But it actually helps the officers as well, because and your witnesses, because you can your victims, you can show them the policy and says, well, look, this is what you can expect from us. And we're not saying that we're going to guarantee taking possession action in every case. We're saying we're going to look at it according to what's appropriate in the circumstances. And we always speak to the perpetrator to get their side of things. So the fact that we want to do that isn't anything unusual. It's just the process that we adopt, and it can help you to kind of justify what you're doing in terms of expectation management for your victims, and also for your officers themselves to know what they should be doing. So a short policy is good, and it might be that you have a more detailed sort of practice document in terms of your procedures internally, but the policy itself shouldn't commit you too much to things that might not be realistic in terms of time frame or action. But equally, you shouldn't rule things out either. So I've seen policies where they'll say we don't use the mandatory grounds, and you kind of think, what? Why would you remove something that's been granted to you by legislation? Because the mandatory ground can be really powerful. But if you've got a breach of an injunction, if you've got a closure order, an abatement notice, a serious criminal offence, one of the conditions is met, it can mean you park all the history and you can go on your mandatory ground. So it's really important to make sure that your policies don't deprive you of some of the tools and powers that are available to you, but equally don't tie you and commit you to using them in any particular case. So if I don't know how regularly people review their policies, but it is something that is worth reviewing from time to time, as well as the training of your officers on the policy, and making sure your officers are familiar with them, because there's nothing worse than an officer admitting to a judge, you know, when they're an ASB officer, that they haven't read the ASB policy. And I ask that question now, but now that I have my fingers burnt, but we shouldn't have to get to the, you know, you assume that people have, and it's not something that would even occur to me to ask until it actually happened to me.
There also, I mean, there's new areas of antisocial behaviour coming up, in particular neighbours all having CCTV cameras outside their properties and recording each other. And a lot of officers and a lot of local authorities aren't sure the rules around the use of CCTV. And another area that's coming up at the moment is doorbells that record who's standing at you, and how wide that recording goes, and how long you keep the recording of the people that came to your door, and whether that's a breach of data protection. And this is an area where I think new policies need to be made, which also adds some training again to understand what you can and can't do, what is a data protection and what isn't, what is intrusive and what isn't. And that's a big area that I'm seeing that is causing a lot of neighbourhood dispute at the moment, with them recording each other and finding that that's harassment to a certain extent, as well as being told by enforcement officers, well, use your recordings, use your phone. This is great evidence, and it is, without a doubt. But also I think we need to know the balance of that and when that becomes intrusive on somebody else.
It's really difficult, isn't it? Because there was that case in the news that BBC reported on, I think it was last week, with the doctor who'd claimed harassment because of the way in which her neighbour had set up his cameras. And I know that in Chambers last week we had Housing Week, and I chaired the session on data protection for social landlords, and that session was devoted to talking about some of these issues. If anybody who's watching is interested, the videos are available through the Chambers website, and you can watch them. You don't have to have been participating live, you can watch them, the recording. But it seems to me that that was a street property that the BBC reported on, but it's a real issue in things like flats where you might have people's front doors facing each other, and the front doors are like this, and you can't really position your camera in many different ways when it comes to that sort of geographical situation that you're met with. But it's about proportionality and about what's appropriate and how long you keep the recordings for, because you'll know if there's something happened or not. And if nothing's happened, those recordings should be being destroyed. It shouldn't be just a case of just collecting material. And do you record just video, or do you record sound? And there's quite a lot that's involved with what you need to consider in your policies. And again, it's expectation management, both victims and perpetrators. Hopefully before you get to the stage of victims and perpetrators, because this is more of a tenancy management issue. Is your experience, are there many people that have got the right sort of policy when it comes to video doorbells?
It's not my experience. I think it's a new area, and I think it's something my clients I'd advise to start looking at, to get policies in respect of audio equipment and new technology that's arising all the time, which can be seen as intrusive. And I think, again, training, perhaps having a policy on it to assist both with local authorities and housing associations. The other area, which I find is a big area coming up, obviously, is social media, which we're all talking about. And we've been discussing within Capsticks ways of resolving this, and whether you take injunctions, you can, but also, is it worth putting a clause in the tenancy agreement that trolling people on social media could be a breach of their tenancy if it's done within the household? That's something to look at as well. How that would be framed, I'm not sure at this moment in time, and it's something for a bigger discussion. But it's a massive area, both for the police and for antisocial behaviour, is trolling people or even grooming over the web, over social media as well. And bullying, massive amounts of bullying going on, which an injunction could be used for schools and young children really suffering with mental health for it. I think it is a big area that's coming up.
Yeah, I agree, because often it starts off that you accept a friend request or the equivalent on whatever social media platform you use, because the two individuals involved get on initially, and then if something sours and you can't unfriend them, or they've got your contact details, and then so you continue to receive messages that you don't want to receive. I'm not sure how one would put that in a tenancy agreement. I'd love to see anyone that's actually successfully done it. But the other reason social media can be quite useful is it's useful to collect evidence. And I have one case that I dealt with for an authority where there were two issues that came up. One was that, I really get on with my neighbour. I don't know what she's talking about with all these accusations that are being made about antisocial behaviour. And it turned out that they'd been essentially slagging their neighbour off on, I think it was Facebook, and the officer was able to get a screen grab of some of that content to be able to say, well, this is the sort of way you're describing your neighbour and how you're referring to her, and the abuse that was being recorded in these messages. But the other reason it was really useful is that this particular tenant claimed that she didn't know how to read or write. And that not only that, she had OCD, which meant she couldn't touch the court bundle. So we had to make arrangements for her. This is pre-COVID. We had to make arrangements for her to have some gloves brought in from Boots so that she could handle the bundle. And then she claimed that she couldn't read or write. And the officer tapped me on the shoulder as I was in the middle of about to start my cross-examination and said, "You might want to take a look at this." And he handed me his phone. And I wondered, why are you showing me your phone? I'm about to start my cross-examination, probably the most stressful part of the trial. I said, "Look at this. She can read and write. This is her Facebook account." And that's what I started with in terms of my questions, which wasn't what I had planned to start my cross-examination with. But it demonstrated not only that she was lying about her learning disability and her inability to touch things without gloves, but that the content was so damning that it said it all. But often when you've got pictures or video evidence, it's so powerful. So social media can be helpful, It's just how when it's used to victimise and bully people. And yeah, I agree. That's something that we're going to have to start looking at in terms of how we can manage what our expectations are as landlords of our tenants.
That brings me on to something, one of the questions that we've looked at, and I do apologise because I wasn't here at the beginning, and it's when mediation is appropriate prior for the community, or the remedies that are appropriate. And with neighbourhood disputes and fallouts over the internet through Facebook, it was just to get across when mediation would be appropriate in some of these cases. And again, I suppose this is going back to our front loading the case, looking at the evidence, looking at our tools in the toolbox prior, but mediation has to be considered as well. And for me, it would be obviously when both parties are willing and they agree to a solution, and drawing up a very carefully worded agreement as to what is and isn't appropriate after the mediation to go forward, including an acceptable behaviour contract. I don't know. And again, that looks great if it falls down that you've drawn a line under the neighbourhood arguments, and it maybe escalates at a later date. But that is a line in the sand to then build your case should it go further, that mediation was stopped at this point. We've tried everything we can, and it's also a good way of explaining to the court that you're using it as a last option. The more enforceable actions that you would take through the court, and these are all the actions that you've taken. I don't know what you feel about mediation and when it would be appropriate.
So a lot of the cases I get involved in have often got to the stage where mediation, it's just too late for mediation, because various measures have been tried, and it's now, well, what do we do next? You know, we now are at the point of needing an injunction or needing to evict this person. But in those cases where you're brought in early on, and I suppose sometimes as lawyers we're brought in when there's already an established problem. But if, as for the officers that are on the call, it's always worth considering. Your situation might not mean that it's appropriate because the behaviour might be too serious. But for cases where it's, I hate using the word low level, but it's at an early stage of the dispute, then it's worth looking at. And you don't have to necessarily have face-to-face mediation, because you can have those, it's called shuffle mediation, where you can have a mediator that visits each party individually, and you try to come to some sort of consensus, because very often we're dealing with people who have a difference of lifestyle in terms of their expectations. And it's been a particular problem in COVID, because you've had families locked down on top of the single professional that's trying to work, and you've got children running around because they're not at school because of lockdown, and the problems that have occurred, so they've been amplified because of the situation we've all been living in, and particularly for the local authority and registered providers housing, it's quite densely populated. We're living in close proximity to one another. So mediation can be valuable in terms of trying to understand what the other's experiencing, and maybe setting some boundaries as to when certain types of behaviour or certain activities within the home can be done so that they have the least impact. It can also help with some of the kind of out-of-the-box solutions. So I remember doing a case where we had an expert report say that the dropping of a paperback book on the flat above this ground floor flat caused intrusive noise. And that's because it was an old building that had been converted according to really old building standards. So it complied, but to drop a paperback book and for that to be causing intrusive noise was quite something. It was a row of terrace houses. And some of the solutions we looked at there were things like carpet, things like lifting speakers off the floor. And then you do start looking at some of the more intrusive work, such as whether you need a suspended ceiling or something like that to help with some of the sound insulation problems. But sometimes as enforcement officers, you're not just looking for the enforcement options. You might be looking at things that are in managing people. You know, how about putting a rug down or carpet, or deciding what's the maximum number you can play your music at before it becomes intrusive, and some of those conversations which maybe even as an officer you can mediate, rather than the two parties having to deal with that face to face?
Oh, yeah, I've definitely had a lot of noise that arises when you're living in close proximity in flats that have problems with sound, and I've had clients that have looked at soundproofing and having injunctions that you play noise at a certain time, stop at a certain time, using headphones, asking people to do that. We've even had noise abatements where we've ended up seizing certain materials as well, noise making machinery has been seized in some of the cases I've done. Talking about COVID as well, I digress a little bit, sorry here, apologise, which brings me on to another question for you, which is, when is possession appropriate, and how has possession been dealt with since COVID because of the memorandum that's been put on taking possession proceedings? And I appreciate that you can go straight away with antisocial behaviour as well, but we've been very reluctant over the last couple of years with COVID in taking possession proceedings, particularly if people need to be locked down in their own homes, and there was a big rush to make sure there's no homeless at that time. To then take eviction proceedings was obviously the wrong thing to do at that time. So what are your experiences or anything that you want to say in respect of possession proceedings going forward now, with COVID still being around and the problems people have had from working from home, having their children at home, and using that as an enforcement tool?
Yeah, it kind of goes to what I was saying about people just having to be sort of locked down with one another has meant sometimes behaviour that would have been perfectly fine has become a problem because people are trying to work while there's DIY going on, or trying to work while there's children running around, or whatever it might be. But in terms of my experience of what the courts are doing, we've been very fortunate in the ASB world in that they have still continued to make closure orders, and closure orders have been categorised as a priority type of case, and courts have still made injunction orders, and judges are making possession orders, even post-COVID, if that's what you can call it, even if we are maybe heading down back to further restrictions, because I think one of the things that judges have realised is when we are all working at home, there's actually an even greater expectation that we have regard to what's going on around us in terms of reining in some of that behaviour. And where there is ASB, I think the judges are treating it seriously. You have to have all your ducks in a row. So you need to have shown that you've tried to other measures short of possession. Now, that's not to say that possession is always the last resort, because sometimes possession might be appropriate because of the type of behaviour. And I would hope that none of you have got a policy that says possession is the last resort, because that's really unhelpful if you haven't followed other measures. But if you're in a position to be able to show that you've tried to deal with the situation without seeking possession, it might be that you want to try seeking an injunction to manage some of that behaviour prior to a possession application. But as long as that, it's not just a document trail, because it's actually about the efforts that have been made prior as well. Those efforts have to have existed. But if those exist and you're able to evidence them, and you have evidence of the ASB being ongoing, so we're not talking about old ASB that was a year ago, judges making possession orders.
Also, what's very powerful is actually saying at the start that you'd be accepting an SPO or a PPO as another enforcement tool that isn't necessarily a complete eviction. It's using it as a tool to stop the antisocial behaviour as well. And it can be quite powerful. It's not seen, and again, draws a line under a certain stage where you've got admissions and you've got a well-drafted order that has recordings of admissions, that any breach thereafter makes it very simple.
Yeah, I agree. And the beauty of that is that you're actually giving somebody a last chance to stay in their home and show that they can comply with the terms and conditions of their tenancy. Very often you can achieve that outcome without them having to go to court and be cross-examined and all of those things. The thing to be aware about is that your order does have to be well drafted. You do have to have a sufficient number of admissions so that if somebody looks at it further down the line, there's enough information there for them to feel comfortable about converting that suspended order into an outright order, or if there's a warrant requested, refusing any application to suspend. So having a well-drafted order is really important to make sure you've recorded all the various things that have been admitted to that have led to the order being made.
Which brings me on to another question. Are the courts being stricter with possessions, but mostly injunctions now? Are you finding in your experience that the judges are less likely to give injunctions or pushing back against them?
My experience is that in the right case, you'll get your order. And so if your evidence is strong enough in that it's detailed and it explains what's been going on, and ideally is from somebody who's a direct witness rather than hearsay evidence, although you can seek orders with hearsay evidence, courts are making injunction orders. And actually what has changed, and I think this might be something to do with COVID, I'm not sure, but when it comes to committal applications, I'm seeing a lot more direct prison sentences rather than suspended prison sentences, which is a bit odd, because I sit in the Crown Court as a recorder, and there one of the things where we get reminded about is that the conditions in custody are really poor for prisoners, particularly at the height of lockdown, where they were in their cells for 23 hours a day, almost solitary confinement, which isn't the norm for the general prison population. And then so just that sometimes factored into how long you would sentence somebody for. But despite that, on the civil side, my experience is that judges are very willing to not only find breaches of orders, but then to punish by way of direct prison sentences. What's your experience, Susan? Are you finding that you're still getting your orders?
Yes. Again, as you said, it's the evidence being right. It's making sure that we're assisting the court to help them get to that order. And the evidence has to be formulated in a way that is easy to get across the salient points that we want for the courts to do. It's also, I think, within orders, really important, going on to contempt, as you said, committal out of the same procedures of injunction. The orders are really carefully drafted with the recordings. And it acts as a great memoir going forward at the committal, what was said at the first one, because those orders all follow through and are helping the judge. If we can help the judge, they're more than willing to meet you and give you what you want as a claimant lawyer or an applicant at that point, I find. But it is, again, the evidence. It's going back to what actions were taken before you did it and evidencing all that and being reasonable at all times. And this is what we need and this is why we need it. Yes, and I am, in answer to your question, finding that since COVID, I think there's been a lot more injunctions, and we've been taking injunctions rather than possession proceedings that would ordinarily be taken as well. And a lot of hearings remotely by video link, which makes it easier for us as lawyers to do that as well nationwide. And that speeds up the process to a certain extent. But yes, I think it's a very powerful tool, working with the police as well, a breach of an injunction. I've always found as a contempt of court that the courts are willing to send to prison if necessary, where they perhaps wouldn't on a criminal similar type of offence to a certain extent. So it can be a very powerful tool, and something that, working again with our partner agencies, is very welcome by the police.
Yeah. There have been a couple of questions on the chat that relate to things like whether the ASB powers can apply to mobile home sites, and things like how long does the notice period need to be in a closure order. Some of that information you'll be able to find in Cornerstone on ASB, which is the book I wrote. Chapter 8 is a chapter dedicated to closure orders for the person that asked that question about the notices, and there's actually some template notices at the back of the book, so you can use those to start your closure order application. A lot of the powers are tenure neutral, so not just closures but injunctions as well. You can even use them against owner occupiers. So you can close somebody's premises even if they own it. And the same is true going to the mobile homes question. Injunctive powers apply across the board. It's really about looking at whether the statutory test has been met, whether you can evidence that the statutory test has been met, and look at it from the shoes of a judge. If you were the judge, would you be able to show the judge that there is antisocial behaviour? Or if it's a community protection notice or a public spaces protection order, say, has there been detrimental effect on the quality of life of those in the locality? And that's really, when you're thinking about enforcement action, what you have to have one eye to is, what is the judge going to make of this, and have I got enough to satisfy them, as well as trying to see if you can resolve it before it gets to enforcement stage.
Going on to one of our other questions then, do you think there's any gaps in the armoury? I personally think for housing associations, because they haven't got the same powers that the local authority have. Again, I keep coming back to that, and it's a partnership working, because a closure order is very appropriate, say in a cuckoo type situation. Injunctions where it's the tenant or the occupiers themselves causing the antisocial behaviour, not necessarily connected to the property. But housing associations, I think, do have limited powers, and to get over that multi-agency working, as I previously said, if we use some of the local authority powers like closure orders or abatement notices, breaches of those then work on to an absolute ground for possession for the housing associations. Do you see a gap in the armoury as it currently stands?
So having looked at the legislation as it was going through Parliament, and then looking at the way it's intended to work, it's in partnership working is intended to work. And if it did work and we were able to persuade our partners to use the tools at their disposal when they were appropriate, and then use our powers when we were required to use them, there aren't any gaps. The problem is that partnership working doesn't always work particularly well, and it's patchy, and sometimes the response you get, and I get this a lot from my housing association clients, they'll say that, well, the police force in this area are very willing to do this, but the police force in that area are not willing, and it's exactly the same situation. And so there seems to be quite a lot of inconsistency across the police, say, or from local authority to local authority, and even between what housing associations are prepared to do. And I think that goes back to training and understanding how you can use the powers, and sometimes using the powers outside of the box in terms of an imaginative way of showing that the test has been met, and using them for things that might not be traditional sort of ASB. But so there aren't any gaps if things were to work properly. The problem is they don't. And it seems to me the main thing is that housing associations would benefit from being able to issue community protection notices, because they're the sort of lower level of enforcement. And although I know of a few local authorities that have given authorisation to their housing associations to do that, because the legislation does provide for that, there aren't very many who've actually taken up that opportunity and utilised them in their own areas. And because of that, what you end up happening is you end up happening with social housing associations saying to the council, well, that's a council job, we want you to act, or the council saying to the police, we want you to act, or vice versa. And that's what causes a delay in the system, and that's what smacks of the very problems that this legislation was intended to correct, which is putting the victim at the centre of everything. And we sometimes, I think we still, even now, despite Pilkington and Dow and lots of other cases, forget that there is a victim who is expecting action, and they're not really concerned with who takes it, but they want that problem to be resolved.
This is a community trigger as well.
Yeah, well, this actually reminded me of something that I know can see Anne's appeared on the screen. One of the things that I've sometimes done where I've had problems with partnership working is said to the client, you can make a trigger application in respect of a partner organisation. Now, I know we shouldn't have to do that because our partners should be working in partnership, but where they're not, that is an option available to you, and I have used it successfully to get people to take action where otherwise they've been reluctant.
Ladies, thank you so much. I suspect you could talk about this all day, and whilst we would love to listen to you talk about it all day, we're going to have to wrap it up here. On behalf of everyone attending, thank you so much for bearing with us with the technical difficulties. That was a fascinating conversation. I really appreciate your time. It was really wonderful, and thank you, Kuljit, particularly for improvising with me whilst Susan resolved her technical issues. So thank you. All it remains for me to do is thank everyone for coming. Thank you so much for the questions that have fed through. We will use those and see what we can do to provide answers going forward. But thank you so much for your attendance, and thank you, ladies, for your very interesting and stimulating conversation. Thank you.